This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about the problem with different degrees of crime and why I believe that fraud by any other name is still fraud and should be punished equally. Pursuant to the New Jersey Code of Criminal Justice, one can be charged with the offense of insurance fraud for knowingly making a false or misleading statement of material fact in connection with an insurance claim. That third-degree offense may be elevated to the second degree by aggregating 5 acts of insurance fraud, the total value of which exceeds $1,000. In the state of New Jersey versus Randi Fleischman, a March 26, 2007 decision of the Supreme Court of New Jersey, the Supreme Court was provided with the first opportunity to construe the New Jersey Statute 2C 21-4.6 penalizing of a false statement as an act of insurance fraud that can be accumulated to elevate insurance fraud to a second-degree offense. The state indicted defendant Randi Fleischman for second-degree insurance fraud. The factual underpinnings for the charge were based on various items of false information contained in defendant's statements to the police and to her automobile insurer in connection with a stolen car claim. On December 4, 2003, after she had made arrangements for a friend to dispose of her 2000 Chrysler Sebring, the defendant contacted the Edison police to report that her car had been stolen. She also telephoned her auto insurer, Liberty Mutual, to report that her car had been stolen. In response to questioning about the claim, she told her insurer that she still possessed the automobile keys and that she had not been trying to sell her car. On December 12, 2003, defendant filed with Liberty Mutual an automobile theft affidavit in which she swore that the automobile had been stolen from the Menlo Park Mall parking lot and that she had no information about the car's whereabouts. Fleischman's affidavit also stated she did not own any other automobile and that her car had not been for sale. Fleischman subsequently confessed that her car had not been stolen and withdrew her insurance claim. She was later indicted for insurance fraud, and she moved to dismiss the second-degree insurance fraud count. The motion court found that the state presented only 3 acts of insurance fraud: defendant's fraudulent report to Liberty Mutual, the false affidavit that she submitted to Liberty Mutual, and defendant's fraudulent police report. Accordingly, the court dismissed count 1, leaving intact the remaining charges because there was not 5 separate acts. The appellate division affirmed count 1's dismissal, holding that each lie told in support of one fraudulent claim in a single document cannot reasonably be seen as a separate act of insurance fraud, but rather only as a component of the one fraudulent claim. Pursuant to the statute, a person commits insurance fraud when one knowingly makes or causes to be made a fictitious, false, fraudulent, or misleading statement of material fact in any record, bill, claim, or other document in writing, electronically, orally, or in any other form that a person attempts to submit a claim for payment, reimbursement, or other benefit pursuant to an insurance policy. The offense is only elevated from the third to the second degree when a person commits 5 or more acts of insurance fraud, and the aggregate value of property, services, or other benefits obtained or sought exceeds $1,000. The statute further provided, quote, each act of insurance fraud shall constitute an additional, separate, and distinct offense, except that 5 or more separate acts may be aggregated for the purpose of establishing liability pursuant to this section. Multiple acts of insurance fraud, which are contained in a single record, bill, claim, application, payment, affidavit, certification, or other document, shall each constitute an additional, separate, and distinct offense for purposes of this subsection. Close quote. Thus, the breadth of the phrase act of insurance fraud for grading purposes depends in part on the breadth of the term statement in subsection A of the Act. No definition of statement answers the question posed by the appeal. The statute's reference to a statement is to the New Jersey Supreme Court ambiguous. Although it is evident that the legislature intended to curb insurance fraud, the Supreme Court could not ignore that the legislature created 2 separate offenses of different degrees. The Supreme Court rejected the argument that more than 5 acts of insurance fraud were perpetrated by defendant when she made 3 statements in support of her fraudulent insurance claim. Therefore, the Supreme Court held that when a defendant provides to officials in connection with a fraudulent claim a document or oral narrative that contains a material fact or facts relating to the claim, each such document or narration is a statement equating to an act of insurance fraud. Because defendants' oral and written statements related to a single claim of a stolen automobile, and since the state presented those 3 acts of insurance fraud to the grand jury, that is, defendant's report to the police, the oral report of the alleged theft to Liberty, and the affidavit submitted to Liberty Mutual in support of her claim, there were only 3, and she cannot have the crime upgraded to a second degree. In my opinion, insurance fraud is a single crime. Adding grades of fraud is an attempt by the legislature to make some types of insurance fraud more criminal than other types of insurance fraud. As silly as this grading system is, it is the law of New Jersey, and the defendant could not be charged with a higher degree of fraud because she only made 3 fraudulent statements. However, her crime was a hard fraud that was premeditated. The legislature should do what other states do, declare insurance fraud of any degree or amount a felony subject to 5 years in state prison, and stop with the silliness of trying to grade different varieties of insurance fraud. Her fraud was serious, but she made fewer statements and therefore can get a lesser sentence. This video was adapted from blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog, where you can subscribe to the blog and receive notice of the blog postings, usually 5, sometimes 6 a week, and also access to the more than 450 posts. You can also subscribe to the videos on YouTube and rumble.com, and if you found them useful, please click on the like button and the rumble button as you do. These videos are available free, and if you find them useful, please tell your friends and colleagues so that they too can subscribe to the blog or the videos or both. And also, if you wish further, more serious and more detailed analysis of the law of insurance and insurance claims, please consider subscribing to my Locals community or my Substack publications. Thank you for your attention.